Hi, this is Irina Shea, and this is part of our Wealth and Wisdom video series. Today, we're going to talk about how do I protect assets from divorce? So let's share screen here and talk through some ideas. Okay, so typically when people come to see us, they're worried about a child's divorce because either they've been through it themselves or a friend, et cetera, has. So the first thing we tell them, of course, is to have that child do a prenuptial or postnuptial agreement. Um, that is done with a family law attorney, not us. Often the children, however, are not really comfortable with that. So unless their spouse comes from a lot of money or they do, typically this is a no from the adult child. So if you, however, are the person you're concerned about and it's a second marriage, we encourage that because you bring separate assets to the marriage and separate children. Another way is in the context of estate planning, of course, is to do a trust. So, what do we mean? A trust for an adult child who is otherwise a responsible person but is married with children, by putting it in what we call a spendthrift trust or asset protection trust. Any inheritance they receive in such a trust, which we draft all the time because pretty much everybody's worried about the possibility of a child's divorce. It's their largest creditor risk. It's a 50% risk. It's just out there. No matter how wonderful your daughter or son-in-law may look now, this is decades and decades of a marriage. It's not known, right? So we often create trust for adult children just to know that there's divorce protection. So inherited assets. Let's pretend that you leave each child $3 million, right? You have two children, each receive $3 million. If we leave it in trust and there is later a divorce, if it's structured properly, and we go into great detail on that, it should not be subject to equitable distribution in a divorce. That is true in New York and New Jersey. Other states can differ, notably Massachusetts and some other. It's more nuanced than that, but we go through this in our consultations in our office. It is a major step, though, in you making sure that your adult child will always have inherited funds separate from their spouse, and they can have financial security for not just themselves, but their children, your grandchildren. So it's very, very powerful. If a trust is not indicated, you just really, really don't want that child's share in trust, or it's not an enormous amount of money. Let's just pretend it's 500,000 to each child, which right now is not big, big, big money. It might just be enough to take care of some expenses for them. You could simply give them the advice, do not commingle your inheritance. Now, you're telling the child, hey, when you inherit this, I'd like you to keep it in a separate investment account in your name only, earmark it for your children. And, it's a pinky promise. You're saying, can you please honor my wish? Right. This works very well, again, New York and New Jersey. It may not work in community property states or other places, but your children, where they live, matters on this. So it's also kind of an uncomfortable conversation that they will have to have with their spouse because they're saying, hey, we're sharing earned income and bonuses, but I'm not sharing this inheritance because my parents and their lawyer said no. That's a little difficult. So if the dollars are over $1 million per child, and if you just have a preference for structure and there's grandchildren, there's bloodline, probably option two is the option that is the most assured. Um, and the one you have control over, because we would be creating that in our office. You can't make the child do a prenup, and you can't make them not commingle or mess it up later. So we talk a lot about this in our office. So if you'd like to learn more, just go to our website, irinashea.com, click the Get Started tab, and there is no charge for our consultations. Thanks.